Hi, this is Tim Santoni, and welcome to the Santoni Spotlight. Today, Sven Buncher joins us. Sven, thanks so much for joining the show.
It's nice to be here.
Before we get started, maybe give our viewers a little bit of sense of your professional background, your history, and kind of a little bit about your law practice today.
Okay, well, we'll try to do that really quick in like 30 seconds. So I originally started out in civil litigation. I did that for about 10 years, doing high-end business litigation, jury trials, and whatnot. After about 10 years, I transferred into family law, but continued with my business litigation practice and brought that into my family law practice. That allows us to handle a wide variety of family law cases which have business litigation issues in or parallel civil litigations. So often I'll have one foot in the family law court while also handling business litigation issues, or maybe a defamation case or something else that's going on. And I am a certified family law specialist.
Great.
Oh, and I should have mentioned.
So people are coming to you obviously at a very difficult time in their life and their relationships and things like that, and the impact of a divorce or dissolution can impact kids' financials for a lifetime. So maybe give us the top one or two scenarios that you see currently based on economic conditions that I know that you have a specialty in something called Marvin actions, but maybe give us an insight into the things you're seeing currently as it relates to the issues that are coming about in those family law cases that do become pretty complex.
Well, in the higher asset cases, we have several scenarios. We'll have the scenario where a person might have started a business prior to marriage, and there can be a significant separate property interest in that business, and then that business might have grown during marriage, and then more businesses have sprung up during the period of the marriage. And so now we have complex issues of determining which portion of the assets would be separate property of the person that had it, and which portion of the assets are community property. In other cases, we have people that acquire real estate holdings, same scenarios, before and during marriage, and they might also have other partners that come in. And often these other partners, whether it's in the real estate issues or the business issues, may need to also be joined to the litigation, and that also creates all sorts of confidentiality issues and privacy issues with their partners, employees, and so forth.
Interesting. So as those complexities arise and things like that, so as a certified specialist in family law and history and business litigation, that gives an advantage. So are you often brought into, as maybe the second or third option after someone's realized that, the first option that they chose maybe wasn't fit for the case?
That's often the case, or sometimes I'm actually brought in as a consultant, and I'll drive up to LA, for example, and I'll help get a case settled at a mediation to avoid trial.
Interesting. So I talked about a little bit earlier, but the Marvin actions I think are something pretty unique. Maybe give our viewers a sense of what a Marvin action is. It's a funny name, but I think that it's becoming more and more common, and my guess is that you're seeing more and more of those.
Yeah, the Marvin actions, they got their name after the famous actor Marvin Lee, and he was sued by his girlfriend. They lived together for many years, but never actually got married. That case was appealed and actually tried twice, and the girlfriend lost twice, trying to prove that she was entitled to a portion of his estate, just as if they were married. We've had several Marvin cases. We handle several a year, some for plaintiff, some for defense. Common law marriage, the urban legend of that, was outlawed in the 1800s, so it's not recognized. So if you have a marital-like relationship but never got married, there can still be claims for spouse support. There still can be claims for division of what would otherwise be community property, but that's not handled in the family court because it's not under the family code. So that's where the civil litigation comes in, because those cases will take place in civil court with a jury trial instead of a judge trial in family court.
Maybe give our viewers a sense of a client or two that you helped, obviously protecting the names of the parties, but where there may be some really amazing outcome or unique outcome that you were able to help them with based on your experience and your firm's breadth of services.
Well, since we just talked about Marvin, we'll talk about Marvin first. These cases are as often same-sex relationships as well as opposite-sex relationships. You'll often get a case where people have been together close to 20 years. They've had children together, which brings them into family law court for paternity and child support issues, but they never got married for various reasons. So you'll have one foot in family law court dealing with custody issues of the children, maybe the dog, and dealing with child support issues. But then you need to have a foot in the civil court dealing with everything else, whether it's determining whether or not there's a support right, a division of property right. There might be disputes over who owns the business litigation type issues. There might even be a defamation case where one spouse is bad-mouthing the other. In the family law cases, what can I say? We have many of the same issues, but it's all litigated in the family court context before a family court judge, and there is no jury. And we have many of the same issues, but under the context of the family code.
Sure. So one issue that we deal with a lot in our practice is a matter that often happens either in the process of a dissolution or after this dissolution's gone on for a while, which is cohabitation. And I think that I know the courts have a varying view and opinion on what cohabitation is, but our understanding is that obviously it impacts support and alimony and things like that.
Yes.
And after a period of time, if there's evidence of cohabitation or one of the partners has been remarried, that can impact support and people go back into court. But maybe give our viewers a sense of what cohabitation means and how it could impact their case, meaning court by court, jurisdiction by jurisdiction, there's probably different rules, but give us an overview of what cohabitation is and kind of how you see it play out in with your cases and your clients.
Okay. Well, in the Marvin case, where non-marital cohabitation, there's actually no technical requirement that you live together. You can still have an agreement to share assets and pay support, and that can still be enforced in civil court. Having cohabitation makes the case much stronger. In a family context, most people are aware, or at least heard, that if you've lived together, if you've been married for 10 years or more, that creates the presumption of what's considered to be a long-term marriage. When you have a long-term marriage, the starting place is that spousal support will be for an indefinite period of time until the payor retires or no longer has income, although we can often litigate that and shorten that or even terminate it. If you've been married for less than 10 years, the rule of thumb is that spousal support will continue for half the duration of marriage. So if you've been married for 9 years, then the rule of thumb is spousal support will continue for 4.5. There's tons of exceptions and circumstances. We can litigate to increase that or decrease that. It's the rule of thumb. The reason for the rule is it's the assumption that the one's party has worked less or been out of the marketplace during marriage as a result of being the homemaker or carrying on certain domestic services. And it's assumed that half the duration of the marriage is enough time to give them time to get their back on their feet and get back in the job market and make up for lost time.
Gotcha. So in those situations where you are litigating that, coming up with different agreements that maybe beyond or within those kind of legal limits, let's just say that you have a client that comes to you and says, hey, Sven, I found out that my ex-wife, I'm paying her support. We believe that she's either remarried or living with a boyfriend, and there's some sort of assets that that she's having benefited from. What's your kind of recommendation to them as it relates to what their options might be in terms of getting that support modified?
Well, first of all, I'd probably recommend they retain you.
Okay.
Because in the past you've been very successful for me doing background investigation, maybe checking out their social media, finding out what kind of relationship they have with this person. They might intentionally be avoiding getting married to continue with spouse support, but otherwise having a marital-like relationship. And if they are living with that person, it automatically creates a presumption of decreased need. And we can often get them lying in deposition saying, oh, they're just a roommate. It doesn't affect any other aspect of my personal expenses. And sometimes you can go out and find out, yes, indeed, they have a very romantic-like relationship with the nice moonlight walks on the beach and so forth, whether it's on social media or doing surveillance. That decreases the spousal support.
Gotcha. Yeah, and that's funny. Recently, we've had a lot more of those cases where the romantic aspect plays into it. They can say, well, they're living together, but the courts want proof that there's some sort of romantic relationship because that's what they've claimed, right? I mean, just to prove what they've already said, which is interesting. Well, Sven, thank you so much for taking some time to come onto the show. Before we let you go, we like to ask a couple personal questions. So when you're not litigating cases in civil court and family court, where do you like to spend some of your free time?
Well, I have a family, so I have a 14-year-old basketball player and a 16-year-old actress. So when I'm not working, because I am very busy, I'm spending time with them. Otherwise, I get on the mountain bike and get a little green in and enjoy nature.
Well, we'll definitely link up all of Sven's information in the show notes below. If you have any questions for Sven or I, please leave them down below and we'll make sure that we get back to you. Sven, thanks so much for coming on.
Thanks for having me.